Hey guys, it's Ben, the Pro State Coach here in Texas. So a topic that I haven't talked about before really, but it's come up a couple times for me this week is motion to confer with the child. So if you don't know what that is, that's a motion. In Texas, judges are allowed to talk to your kids at the age of 12. It means they're allowed to. It doesn't mean that they have to, but they can. I have seen them go as young as 9, and I've seen them decline altogether, all the way through to the age of maturity. So kind of a crapshoot. You'd have to figure out your judge, but it's an obvious reasons. It's a very powerful pleading because you are saying, look, judge, you don't have to listen to me. Talk to my kids. So a few things to consider, though, if you are thinking about filing that, that I think can sneak up and bite some people is, so if if you're going to file a motion to confer, number one, talk to your kid about this and really ask them, what is it that they think they want? They want to live with you primarily. They want to live with your ex primarily. They want 50-50. Okay, get your arms around really the what, right? And then get through to the why, because and then this is going to take some honesty on your behalf, and no one's going to know what's going on here but you. But if your kids want to go live with the other parent primarily, and it's just because you've got rules, that's probably not best for them. They're kids, and they just want to go where it's more fun, right? So, maybe, ask people in your life for impressions or talk about this, but be smart about it. If you're the guy or the mom with all the rules, and then the kids are saying, I want to go to mom, I want to live with the other parent's house. Look, it's just because you got rules, man. Stick to your guns and do what you got to do. So that's one part of it. But another one is if there's any other pleadings going on, or if the relationship between you and your ex is really contentious, your kids know this. And it always makes me nervous to file a motion to confer, because then, let's just say I file it, right, against my ex, a motion to confer. I'm going to file it. Man, when my kids go back over to my ex's house, she's going to grill them like crazy. It's going to be highly contentious. How could you betray me? She's going to be all over them. And that's hard, whether they're 12 or 16. So, prepare however you can do that based on your situation, for your kids to understand that this might be a little noisy for a minute. Your mom or your dad might feel really hurt and kind of take it out on you. I had one guy that it actually went pretty well. He let his kids read the motion so that nothing could be misconstrued. Your father says that I'm a terrible mother and that you guys want to live with him. Actually, that's not at all what it said, because I read it. I know that comment I just made will probably catch me some heat from people saying you leave kids out of this. But in this situation, when dealing with teenagers, they're not stupid. And frankly, a motion to confer says nothing other than petitioner feels that the children will express to the judge, their wishes and their wants in this situation, period. That's it. I don't mind them reading that. I don't want them to see or hear anything ugly or allegations or other things, and that's not included. So, so be prepared for that, and prepare them and figure out some sort of plan or talk about how to do that. I've had a couple guys do them, or people do them, right before going on a long vacation, that they'll file that with the children. And they leave for a week, right? So that the other parent can kind of simmer down for a little bit before the kids come back and emotions can drop down. After that, hook it to your modification. I'm filing a modification to, swap custody or move to 50-50 or whatever the case may be. And here's a motion to confer. That's a really strong pleading, because you're saying, Judge, everybody in my little family is on board with this but my ex. And, it's strong. But do cover your bases and protect your children from it, because this is hard for them, man. They got a messed up life, and it's not one that you designed for them. And so you need to be the parent here and protect them. And also don't do it just because, hey, you're the fun parent and you don't have any rules and whatever, and so you're going to win, right, by essentially being a Disneyland parent. It's not good for your kids either, and you know it, and I know it. But you're the one that gets to choose to act in their best interests or not. But after that, man, file that, and then the judge is going to do what he's going to do. He doesn't have to talk to your kids. He can dismiss that. He can decline that. In some cases, it goes totally haywire, and he goes, well, I'm not going to talk to them, but I want an amicus to talk to them. Now you got a lawyer that you're paying for that you didn't ask for. Object like mad to them, and I'll cover that in another video. Keep amicuses and guardian ad litems as far away from your case as you can. Therapists as well. These people do no good. They will not help you. They will cost you gobs of money, and if you don't do exactly what they want the way they want it, they will hurt you badly. So anyway, just some thoughts on a motion to confer. Very powerful pleading, and one that you need to be very careful with. So you guys can find me at prosecoachtx.com. I also have the Pro Se University, and the links are below in the description. It's Texas' first and only, online school to teach you how to do a lot of this stuff. You don't need a lawyer for a single thing in family law. Not a one. Not a single thing. It's not easy, but it's not hard. It's just stressful. But you can do it. Thanks, guys, for listening. See you next week.